Yes, Mr. MacDonald.
My Lord, I'm most grateful to your lordships for having allowed me the indulgence of a few minutes lateness, which was attributable to what my taxi driver called it being one of them mornings.
Right. Keep going, Mr. MacDonald.
My Lords, may I, in case I forget, in the remaining matters I have to deal with, may I hand up two documents which relate to points we debated yesterday. First of all, my Lord Justice Newey, when I was dealing with the late disclosure of the VAT documents, asked me whether we had all along the revenues inquiry and the answer to it. And I said I thought we had, but I would correct that if I was wrong. I was entirely wrong, and my learned friends instructing solicitors will have known that, because what they sent us under cover of a letter dated the 11th of November was all those documents. That's to say the VAT forms and the revenue inquiry, Mr. Sargent's email commenting on it to Mr. Hughes and so Mr. Barker and so forth. And if I may, just to make that good, I'll hand up copies of.
You can hand it up if you want to, but I will only look at it if it's sent electronically, Mr. MacDonald.
Right.
I don't use paper.
And I ought to see it as well, really, because I haven't had any notice of it.
I'll pass it to my learned friend.
Yes.
And she'll be able to confirm with her solicitors that that is the letter they sent us, and it lists what they enclose. And my Lord, I will arrange for it to be sent to the court electronically, and if your lordships have time to look at it, your lordships will see that it lists what they sent us.
Okay. Subject to Miss Anderson's comments, I would be grateful if you have a paper copy there. Could I have it, please? Oh. Because I don't work
given
with
me
the
an
electronic.
extra
Yes, my Lord.
I'll come. Thank you.
I mean, if you're going to actually refer to it now and you can't send it electronically, even I would look at it under protest, Mr. MacDonald.
I think if Lord Justice Newey, whose point it was, has a glance at it, he'll be able to let me know if he wants me to say anything more about it.
Okay.
I'm not sure whether you want me to deal with the point now. What my instructing solicitor reminds me that point 3, of course, makes the point that some of these had already been disclosed. So I don't accept the proposition. If the proposition is being put that was the first disclosure of all of these for the first time, that's not right on the face of the letter. But I'll investigate the position further.
Well, if it's on the face of the letter, I'm not sure you need to deal with it now.
I don't know what turns on this.
No, nor do I. Right.
The other document is a document which was very much in the bundles at the trial, and I'm afraid I can't explain its omission from the supplemental bundle. I think that there was an argument.
What are you're trying to put something in?
Yeah. Yes.
Is it in the not agreed bundle? There was a bundle called Not Agreed. What are you trying to put in?
What I'm trying to put in is the one-pager, if your lordship remembers what that is.
Yes, I do. And date of the one-pager?
10th of May 2012.
Well, is that not tab 39 in the unagreed bundle? Or We were sent the unagreed bundle, and that is the emails of the 10th of May. I don't think it is a one-pager. No.
We do have at page 360 of the unagreed bundle an email from Chris Barker at 8:47 on the 10th of May.
Yeah, that's it.
That is it.
Yes,
That's
is
it. Okay, well then we don't need it
That's
put
it.
in.
My lord, would your lordship give me that page number again?
Yes, 360 in the additional clip.
Yeah, okay, it's not really a one-pager, but anyway.
Oh, well, that's, I'll have to
They called it a one-pager.
explore this, because my supplemental bundle, which was provided electronically by my learned friends instructing solicitors, ends with page.
Yes.
It's not the supplemental bundle.
It's
the
unagreed
agreed,
bundle.
your bundle.
It's your unagreed bundle, which never got put in because you said you didn't need it anymore, which contains about 14 pages of additional documents numbered sequentially from the end of the supplemental
Right.
bundle.
I didn't realise your lordships had that. We simply decided not to make a fuss about it.
And now you're changing your mind. So,
Well,
I'm not saying you're making a fuss.
Well-
The document is the 10th of May 2012, email 8:47, and we've read it.
and may I make a submission about
Yes,
it?
of course you can.
The submission is that really throughout the evidence at trial and I'm afraid throughout his lordship's judgment, there are references to the problem explained in the one-pager which are inaccurate.
What do you mean inaccurate? The references are inaccurate, or the problem was not accurately identified?
The problem was not accurately identified. It's a very short point, but it's actually quite important throughout the case.
Why?
May I take your lordship to what Mr. Barker said?
Yes.
If your lordship would look at the email to which he's replying, which is at the top of the page, behind it, I expect, in what your lordship's looking at. This is from Mr. Sargent of the 10th of May at 8:24 in the morning. So it's before the meeting that took place on that day. It's to Chris Barker. It says, following our last meeting, I think you were due to circulate a one-pager dealing with the potential taxable event for Gary joining us and being granted equity. Can you circulate this, please? And he replies 20 minutes later, hi David, I've looked at this, and as long as Gary is not going to be a director of the company and cannot be seen to be acting as if he's a director and is not an employee of the company, then there should not be a taxable event. This would have been significantly different had the structure stayed as a limited company and he became an employee director. If you were to insist on Gary being a director of the company, as distinct from, for example, a shareholder or a beneficial owner without legal ownership of shares, he would, if you were to insist on him being a director of the company, he would be subject to income tax on the difference between the price he pays for the shares par, I suspect. I mean, he's envisaging that these £1 shares would be, Gary would pay £20 for these £1 shares and the market value of those shares. Hopefully, with the LLP structure, he will not feel the need to be a director of the limited company.
But whether that was right or wrong doesn't matter, does it? If everybody proceeded on the basis that it was right and that it was problematic.
Yes, but at the time, everybody involved. I'm not sure that I should include my client in that, but everybody involved on the defendant side would have fully understood what this accountant was saying.
Well,
the problem.
Surely then, I mean, presumably that was explored in evidence.
Not particularly, because the point was obvious. But the problem was often referred to, including submissions made to this court, and certainly many references by the judgment, as being a difficulty preventing Mr. Keane being a shareholder of DRS Limited, and it wasn't. That wasn't the problem.
I mean, the difficulty is, it might well be, given what Kingston Smith had said, that Mr. Keane should have thought to himself, there's no problem here. I'll just take the DRSL shares or an interest in the DRSL shares. But the evidence was that that wasn't what he said, and the judge has made findings that that wasn't what he said, and the judge has made findings that the matter was then to be the subject of investigation.
Yes.
Now, that may have been very unwise of Mr. Keane, but unless you go behind those findings by the judge, it doesn't particularly matter whether he was wise or not, does it?
Yes, but the judge proceeded, and we've all really proceeded on the basis that this was going to have to be investigated, and a way round this problem had got to be found. But the investigation would have been very simple, as your lordship has just pointed out.
Well, you say
For
that,
people-
but that's not what the judge found. He found that the investigation didn't reach a concluded solution.
Well, what the judge found, and I'm going back over the submission yesterday afternoon, which my lord quite
The
fairly
first
commented.
sentence of paragraph 215. The investigations produced a potential solution. The evidence establishes that the discussions were not concluded.
Yes, and that was because they didn't need to be concluded.
Well, that's not the judge's finding.
May I go to the passage my lady's
215.
directing me to? Well, yes, exactly, my lady. What that is part of, or reflects my submissions, that starting from the identification of that problem, the idea was, in Mr. Sargent's words in his email of the 6th of August, the idea was that there should be a partnership to hold the shares in DRS. that's, as we know, although that partnership looked as though it wasn't meeting with any opposition from any of the defendants, Mr. Sargent drafted or approved after amendment the Kingston Smith drafts. He circulated them to the others on the 6th of August. He'd made some comments of his own. None of the others objected. Mr. Sargent went on tinkering with the draft and produced a further amended draft on, I think, the 22nd of August. And there the email correspondence just dries up or stops dead.
The judge found they were never finalised.
Yes, and the judge, my submission was that on the balance of probabilities they were finalised.
Oh, but so what? Sorry, I don't mean that disrespectfully.
I know you don't.
The judge found they were never finalised.
Yes, the judge had to make a finding of fact about it,
Yes.
and he felt that the right finding of fact was that they weren't ever finalised. Finalised simply would have simply meant signing off the drafts when Mr. Sargent had finished with them by, I think, the 22nd of August. But my client's evidence was that he believed that that had happened. The judge wasn't prepared to draw that inference, and so decided that they weren't ever finalised. Yes. Exactly. Yeah. But I mean that's not a problem for me, for my submissions.
Well, it's not a problem for you if the findings the judge made, the other findings the judge made, were open to him.
Yes.
And the question you're dealing with is whether that is the case.
Yes, that's right. That's right. But in understanding the story between the 10th of May or after the 10th of May, when everybody was supposed to be investigating this problem, the problem was simply how to proceed with the association which they were discussing with my client without inviting my client to be a director of the limited company.
I mean, it really doesn't matter.
It doesn't
I mean,
matter.
the whole thing stops as at the 18th of June.
Yes.
Because the question, what you're defending, is the judge's finding that a contract was made on the 27th of April and varied and brought into effect on the 18th of June.
Yeah.
And thereafter, although we're sometimes in some circumstances able to look at post-contractual evidence to indicate whether there was a contract or not, it's generally an undesirable practice. And in this case, it doesn't seem to make much difference at all, because we need to be satisfied that the judge was open to the judge to make those two findings.
Yes.
And we've been over that yesterday.
Yes, and
You say he was. And
without-
we fully understand that submission.
without embarking again on yesterday's argument, I mean, it was a sensible conclusion for the judge and a justifiable conclusion in terms of findings of fact, because the LLP wasn't going to work fairly unless Mr. Keane had an equal interest with the others in the limited company, which was going to be clawing back the assets of the LLP under the Kingston Smith scheme. I went over all that tedious length yesterday.
Mm-hmm.
Well, that's simply the result of my thinking your lordship should have that email and being unaware you've got it already.
No, that's helpful because it's now before us. I mean, the only other thing we would like, for the sake of completeness, and don't read anything into this, is we would like the full transcripts of the cross-examination of the parts we've only got extracts from at the moment, please.
Yes.
Well, we've prepared a hard copy and electronic bundle in the court's usual form, of which there are, I hope, 6 copies physically in court right now.
Right, we don't want them right now. We
No.
would just like them set. Well, personally, I'm sure my lord would like them in the physical. I would like them electronically, and my lady, I don't know the answer.
Both, please.
I too would like both.
Yeah.
Not
Well,
least
we'll-
because the electronic version is searchable.
We'll arrange that.
Thank you.
It's a great pity that we're not going to be able to debate with your lordships the conclusions that emerged from reading them. But
Well, it's not really that. It's that the reason I would like to see them personally, and I suspect it's the same for my lord and my lady, is that is simply that it's difficult to get context from extracts. You do get the context, but it's not that we're seeking to troll, believe me, through the entirety of the trial, but we do just want to see the context to the allegations that are made, in case, in our judgments, we want to make any comments about what happened.
certainly, well, then I'm delighted that your lordships have reached that point. I said I needed to say a few more words about the pleading point and
Yes.
deal with the second part of my skeleton argument submissions on that. And then your lordship indicated that I should say a few words about the allegations about the way that trial was handled. If your lordships would pick up my skeleton at the back of the core bundle, tab 14.
Paragraph?
7, paragraph 7, the alternative way of putting it was pleaded in the particulars of claim.
Is this the constructive trust?
Yes, and the this is really dealing with the oddity that the claim form had a very simple prayer which is quoted in paragraph 3. It's claims simply a declaration that my client and the first to fourth defendants have carried on the business of holding and managing the shares of the fifth defendant in partnership since about 20th August 2012, then an order that that be dissolved, etc. And the prayer to the particulars of claim was different from that. I don't know if your lordships remember the prayer to the particulars of the claim, which is in the core bundle at tab 9. The prayer against the first to fourth defendants is at page 129. And my client claimed against them a declaration that they hold their shares in the fifth defendant, that's DRS Limited, in trust for themselves and him in equal shares, together with an order that he be appointed jointly with those defendants to be a trustee, and an order that the trust affecting the shares of the company be executed with all necessary accounts and inquiries. Alternatively, damages and or an indemnity for breach of contract and or fiduciary duty and or negligent misrepresentation relating to the execution by the claimant of transfers of fractions of his interest in the company to the LLP on the 22nd of May and 22nd November, sorry, the other way round, fractions of his interest in the LLP to the company on the 22nd of May and 22nd November. And those were the dates of what we've called the MIPers, which I think your lordships are fully familiar with and will have read. And I've made some points about them already. So no mention of partnership in the prayer in the particulars of claim against the defendants.
Comparing with the prayer to the claim form, what you've got really reflects 1B of the claim form, doesn't it? On page 110. So 1B was
Yes,
seeking declaration.
Yes.
A's missed out.
It's the alternative prayer for a constructive trust.
So what's the point?
And the point is that wasn't pursued at the trial because the further documents showing that there was a partnership holding the company as from the 4th of April caused us to focus on the partnership and not pursue the constructive trust. And the judge didn't adopt the constructive trust either.
He wasn't asked to by anybody.
No, he wasn't. But the last part of the skeleton on ground one brought us to Hawksworth, and your lordship asked me whether I was going to show you Hawksworth, and I will. It's in the authorities bundle. Tab 13. and the details of factual issues in this case don't matter, but at paragraph 39, Lord Justice Tomlinson, who was effectively giving the judgment of the court, said, Mr. Pratt told us that he made clear to the judge at the outset, or when it first became relevant, his objection that the evidence concerning the sound attenuation software was irrelevant. He said that he thought the judge had taken that point on board, and furthermore he said that paragraph 19 of his written closing submissions was written with that expressly in mind. His approach throughout was that the defendant's pleading simply didn't permit the judge to place any reliance upon anything that was said concerning the sound attenuation software. Mr. Pratt considered that it was sufficient to make it clear to the judge that the evidence being deployed by the defendant on that score was irrelevant, as falling outside the confines of the pleaded case. Some guidance as to how counsel should react in circumstances of this sort given by Lord Justice Lawton in Rolls Steel against British Steel, and he the reason we haven't cited that case or included it in the authorities is that all your lordships need is the quotation from Lord Justice Lawton. I wish to add a comment about the pleading points which have had to be considered in this appeal. From the way they were raised by counsel and dealt with by the judge, I was left with the impression that neither the judge nor defending counsel appreciated as fully as they should have done the need for precision and expedition when dealing with pleading points. My recent experience in this court shows that some counsel and judges are not giving pleadings the attention which they should.
I think we've read that, and
yes,
from Lawton.
Yeah.
And then he goes on to say, does he, if you don't do that, you can't do it later.
Yes. And then in the White Book,
Is this a note in the White Book? Is it a note in the White Book?
it's at paragraph 16.0.1 in the White Book. A lengthy paragraph headed editorial introduction. And it says on page 594, about 8 lines from the top, complaints that a party was permitted to rely upon an unpleaded point at trial cannot be raised by way of appeal unless at the trial the complaining party invited the judge to rule upon the point and insisted upon a ruling.
Yes.
If this is done and a ruling preventing departure from the pleading is made, the other parties would then have an opportunity to seek permission to amend his pleading. And that's based on Hawksworth.
Yes.
We rely on that.
Yes.
Now, as far as the complaints about the judge's conduct of the trial are concerned,
Could you deal with one particularly for me, Mr. MacDonald? And I don't think we need to look at it. In the course of the trial, the judge was obviously aware that Mr. Keane was going to be cross-examined about things in his witness statement.
things...
In his witness statement.
Yes, yes.
And particular periods of time. And at one point, in fact, at several points, he said, hang on, Miss Anderson, I want to make sure that Mr. Keane is aware of what he said in his witness statement. And and then at one point he read out, I think it's page 48, I may be wrong, he read out sections of his witness statement, and then later he said, now you're asking about this document, Miss Anderson, you must now let him read the document in its entirety, and you must let him read paragraph X of his witness statement before you ask him any questions. Now, it won't surprise you to know that I have been a barrister myself in the past, and barristers quite commonly ask in cross-examination open questions about things that are in the witness statement with the objective of getting the witness to say something completely different, and then say to the witness, aha, what do you say about this in your witness statement? You said exactly the reverse. Now, I suspect, Mr. MacDonald, if I know you as well as I do, that you've used that tactic yourself in the past.
Occasionally it's unavoidable.
Occasionally it's unavoidable. But the point is that it is, and judges, you know, I'm aware that judges sometimes do what this judge did and say it's not really fair to ask him this question without letting him read certain groundwork. But it isn't good practice, is it? Or that's what I'm asking you, for the judge to do that, because it does look like a rather unfair protection of the witness from what is a normal and perhaps fair approach to cross-examination. What do you say about that?
In general, Lord, I would entirely accept that comment. But reading through the interventions complained of in their entirety, which I had to do in order to deal with them.
Yes.
Because it seemed to me that with, I can't remember how many there were, 58, I think, complaints, it was really impossible to make any general submission.
But some of your comments end up with the words, I think this one does, this was an entirely appropriate thing for the judge to do.
Yes.
Now, I mean, I understand why you submit that, and it's an entirely proper submission to make, but it may, what I'm putting to you is it may be wrong, and it's if not inappropriate, it may be undesirable.
In general, I would entirely accept that. Clearly, a judge shouldn't help a witness who's under pressure.
Yeah, I mean, that's what it looks a bit like.
Yes. All I can say is that my responses to all those complaints, including the one that your Lordship has mentioned, and there were others of that kind, as your Lordship has also mentioned, was really reinforced, I suppose, when I was formulating the individual submissions by my recollections of the trial, at which there were indications that the judge felt that, without criticizing my learned friend, felt that Mr. Keane was being put under excessive pressure by my learned friend. He was
being asked difficult questions.
Well, he was repeatedly accused of lying. I mean, questions were frequently initiated with a suggestion that the evidence that was being given was a deliberate lie.
Well, they couldn't both be right. Sorry.
Oh, the passage my lord has taken you to was a passage in which Ms. Anderson was simply asking, if you say that there was an offer, where is it in your witness statement? Now, that's not an unfair question to ask, and nor is it unduly pressurising. But the judge insists on going through the paragraphs of the witness statement that Ms. Anderson is laying the ground for cross-examining about?
My lady, since your lordship is asking me about one of these
Well,
incidents, may I?
It's number 5 in your response, if it
Yes,
helps.
may I
And
find
you say yourself,
what I said about it?
you say yourself that it was a course of questioning that started with, when do you say any other offer was made? Now, that's not you're lying or unduly pressurising, is it? It's your paragraph 9, Mr. MacDonald, if it helps.
Yes, I'm just looking for the two documents I need. One is the
It's your paragraph 9 in the answers to the complaints of intervention by the judge.
And in the
I'm simply looking, my lord, for my document.
Yes,
that's what
and
that's what I'm pointing you to.
yeah, and in the
Paragraph
supplemental
9.
well, in the supplemental bundle,
which bundle?
it's page 7.
It's in the supplemental bundle. I'll find it.
And the comment is at page 34, I think, in the supplemental bundle.
Lord,
So you want pages 7 and 34 in the sub.
I'm sorry to be slow about this, but
It's why I've got 3 screens, Mr. McCall.
I'll find it.
yeah, I hope I. Yes, I see. I've put my supplemental bundle right over here.
If you give it to me, I'll find it for you.
Yes, it's tabs 2 and 3 of the supplemental bundle, isn't it?
Yes, pages 7 and 34.
Well, first of all, the judge is establishing for his own information or assistance in the management of the trial what parts of the witness statement of Mr. Keane are being cross-examined about.
Well, but that's the unfair protection, isn't it? Because Ms. Anderson was saying it's nowhere in your witness statement. That was the import of her cross-examination. So the judge then requires her to identify the paragraphs where it could be, and then he takes Mr. Keane through those paragraphs. And what my lord put to you was that looked as though, or could look as though, he was unfairly protecting Mr. Keane from perfectly reasonable cross-examination. And your response was, well, the question started with your lying, and that was unfair, and it was perfectly proper for him to protect Mr. Keane. But I don't see in your response to this passage any suggestion that Ms. Anderson was unfairly suggesting Mr. Keane was lying at the outset. That's really the point I was putting to you.
And you then use your formula, which is charming, as I'd expect, Mr. MacDonald. No possible complaint can be made of that helpful intervention, which is charming, but I'm suggesting to you that something else could be said.
The trouble is about dealing with this, and I'm not trying to evade your lordship's point, which I accept as a general point without qualification. But the difficulty about it is that
see, let's cut to the chase.
This
Yeah.
this begins at page 46, line 20, whereas
You need to go back to 44, line 22, which we haven't got.
yes, and I mean, if we were dealing with this in detail as part of the appeal hearing, and we had the transcript bundle, which we've got but hasn't yet.
Look, I get your difficulty, and to be absolutely clear, speaking for myself, and I think also my colleagues will say otherwise, we are unlikely to allow the appeal on the ground that the trial was conducted unfairly. That, to me, seems rather a bridge too far. What we are concerned about is that since the case appears to have happened in my court, and it raises issues of concern as to trial conduct, it might be inappropriate to say nothing about it if there were genuine concerns about aspects of what happened, just in order to give guidance to judges in the future. I think we all accept that if you can point to 68 interruptions in cross-examination in one day, all of which are in the same direction, some things may have gone a little bit wrong. And the one that I identify as being pervasive through all the interventions is what I raised with you. And I wanted your submissions because some judges do this, right? They say when counsel for the defendant in this case gets up and says, I'm going to cross-examine about X, they say, well, before you do that, I want you to let the witness read everything and see everything. And counsel gets aggrieved because counsel thinks that that's unfair, because the whole point is this is evidence that the witness is supposed to remember. And if another answer is given when asked blind what the answer to the question is, having prepared the ground and made sure that he or she is giving a consistent story is not really fair. Now, you may say, well, it is only fair to do that, but that would be a change from the way that historically counsel have been allowed to proceed. I mean, judges have proceeded and counsel have been allowed to proceed. So that's why I'm asking you, because just saying no possible complaint is, as I say, charming but not helpful.
Well, what I started to say a few minutes ago was perhaps going too far, which was that attending the cross-examination of Mr. Keane, one did, I did, shall I say, form a feel, shall we say, that the judge was concerned to protect Mr. Keane because he had decided that he was a truthful witness. He decided he was a witness who was trying to tell the truth in answer to the questions put to him, but that he wasn't very he wasn't sufficiently familiar with the documents in the case and the factual history that he was being asked about, even though he had been part of it 10 years ago. He needed some protection from the judge.
Can I ask you about another passage which sort of ties in with that? So this is page 29 in the supplemental bundle.
29.
29, day 3, page 7.
Page 45.
No, sorry, it's page 29 in the bundle. So this is behind tab 2.
Oh.
Your comment is at page 45.
Yes, sorry.
But
Sorry.
the original passage is at page 29. And so Miss Anderson is saying it's so obvious that you're not telling the truth. Mr. Keane says no, and then the judge says it's not a question of not telling the truth. You have many times accused him of telling lies. I don't think this is this sort of case at all, and so on.
Yes.
Now,
That's-
as you say plainly, it was the judge's view at this stage that Mr. Keane was trying to tell the truth. But is it appropriate for a judge to say to a witness when it's being put to him that he's not telling the truth, that actually he's telling the truth?
Well, I would respectfully suggest that a judge is entitled to be trusted by the Court of Appeal over this sort of thing. Sometimes, all of the members of the court have been judges and are aware of the different sorts of witnesses who give evidence before them, and sometimes they, in order that justice may be done, in other words, in order that their evidence isn't is given spontaneously and without they're feeling excessively, shall I say, pressurized, that they need to be protected one way or another against a particular line of cross-examination.
Well,
I
I mean, I think it's even more stark than that. Of course, there will be occasions where a witness is appropriately protected by the court. Inappropriate pressure, bullying, any kind of that sort of conduct should be prevented. But here, he's actually saying, in the middle of a witness's evidence, I have decided that this witness is telling the truth, when counsel is putting that the witness is not. Is that appropriate?
Well, if the judge has formed that view and considers that cross-examining counsel is persisting with your lying sort of style of questioning.
But then shouldn't he wait? I mean, there are two things there. Shouldn't he, A, wait before forming a view? It is a judicial function not to decide cases in the middle of the evidence.
Absolutely.
And secondly, the appropriate response, if he believes the witness is being bullied or the cross-examination is continuing at excessive length to repeat points that have already been answered, is to say, you've asked that, the witness says he is telling the truth, you say he is lying, I will have to decide that later. Isn't that right?
That would be a perfect form of intervention, my Lord. Yes, in that situation.
Yeah.
But,
Well, I mean, there we are. I mean, I think in a way it's a matter for us, but it's helpful, Mr. MacDonald. Thank you.
Is there anything else your lordships would wish to hear on
No.
from me?
No. Thank you. Yes, Ms. Anderson.
Lords, I can be very short. I don't propose to say anything about the interventions, save one thing, that this case was not about whether each individual intervention could be justified in the way that Mr. MacDonald seeks to do. It was about the level, nature and excessive amount of intervention. But I propose to say no more about it. As your lordships can probably imagine, it was with some reticence that I even embarked upon raising that, but I await your lordship's judgment with interest on the point. Going back, if I may, to the main grounds of appeal, on we're calling it the pleading point. I hope I made clear that it's more than the pleading point, because it's the fact that there is and was no evidence to support any of the cases being advanced by anybody. So just to be clear, my learned friend did not pursue in any degree of vigour at trial in his closing.
Did not pursue what? Oh, constructive.
Constructive trust argument. He didn't pursue the argument that there was a signed version of the August documents. By that I mean the partnership agreement and deed of accession. And he didn't proceed with an argument that had been brought into effect by some form of conduct. Nor did he support the eventual outcome that the judge came for. He did try to argue for a case outside his pleading. And my learned friend, for all his charm, cannot escape the fact that he is responsible, in part, not wholly, for the fact that the judge was led astray. The judge was led astray because, against the face of the evidence, it was clear that there was no support for any other partnership other than, he could have tried to pursue the argument post-August 2012, but he decided not to. The reason he led the judge astray was because, in closing, Mr. MacDonald was urging upon the judge that there was a partnership which came into existence at a different point, and an earlier point. And indeed, you know that eventually, after the hearing and after the judgment had been handed down, my learned friend did apply for permission to amend to bring it into line with the judgment. And of course, I couldn't resist it because the judge had already indicated in his judgment that he was prepared to accede to such an amendment. But my learned friend cannot escape responsibility for the fact that he was urging upon the judge something that was out with his pleaded case. He also can't escape.
I mean, you knew. I'm afraid I've lost it, but he summarises paragraph 176, Mr. MacDonald's submission.
Yeah.
And he says in that summary, which you must have known, that by the end of the trial, Mr. MacDonald was submitting that by the 10th of May 2012 meeting, the parties had agreed or intended that Mr. Keane would have an equal capital and profit share in the LLP, subject to any arrangements required to implement Kingston Smith's tax avoidance scheme.
Yes, and he goes on to say in C that the shares were already owned by them by result of VAT documents.
Which is the point that he's been majoring on in his submissions. But
the point about that is, irrespective of any pleading point, and this is really the answer to Hawkesworth, because this isn't really a Hawkesworth case in my submission.
right.
That there can't be any doubt that I was objecting in closing to the suggestion that I was taking the point that the case that was now being advanced was not the case that had been pleaded. That that's absolutely.
Then why didn't you say to the judge, this case that is being advanced is not properly pleaded? It must be. It's not open to you or to my friend to argue, for you to decide, or you, my friend, to argue. If he doesn't make an amendment, I shall be making that point to the Court of Appeal.
Well, there's 2 points. I couldn't have anticipated, even my learned friend, if accepts, that nobody could have anticipated the way the judge eventually went, which was out with the pleadings on a different basis. The best I could have accepted, and what I did object to, was the suggestion that there was a partnership in effect around the VAT documents, namely around the 4th of April. And I did clearly object to it. True it is, I didn't ask the judge to rule then and there in relation to it. But the point about Hawksworth is that was my learned friend deprived of the opportunity to amend to deal with that point? Well, it wouldn't have helped him because, of course, the linked question in relation to this was the fact that there was no evidence to support that.
But this is a different point, you see. I mean, your point on appeal, really, ground 2, is that, as I understand it, is that there wasn't any evidence for what the judge found. And Mr. MacDonald's answer to that is not a pleading point. His answer to that is it was open to the judge to do a bit of blue sky thinking. I mean, I'm being deliberately colourful. Do a bit of blue sky thinking, piece together what on a balance of probabilities the evidence showed was the most likely thing to have happened, and find in that way. Yeah, if he's right, he'll win.
And I mean, the point is, he plainly can't do that.
But that's another submission. It's not a pleading submission.
Well, no, but the reason the pleading point is important is because what Hawksworth is looking at is to say that was he deprived of the opportunity of making an amendment? And that's my point. He wasn't deprived of the opportunity of making an amendment. His own case is that it had all been put in a letter before he was involved, before the trial, and therefore he was alert to the point. What Hawksworth is dealing with is a situation where suddenly out of the blue, somebody takes the point that the case is being advanced differently from the pleading, and he's deprived of the opportunity of doing that. He hasn't said he's been deprived of the opportunity of doing it. He tried, again, we have to be very careful with the charming Mr. MacDonald. He tried to suggest, but when he'd come to the case recently, well, your lordships will, I hope, have the point, but perhaps not, because I'm not sure it appears from the bundle. But this case had originally been listed to be heard in October 2021 with Mr. MacDonald as counsel. Mr. MacDonald, unfortunately, the case had to go off at the very last minute because of Mr. MacDonald being hospitalised. But as a result, when the case came back for trial, Mr. MacDonald had been involved in it for months. And of course, it was during that period that the so-called new documents on the VAT appeared. You've already have the point that it's not quite the way that Mr. MacDonald puts it, because some of those documents were already disclosed. True it is, there were some that were disclosed then in November and in February. But this is firmly when Mr. MacDonald is in steer of is the captain of the ship. And the fact is, for whatever reason, despite the disparity, there's two disparities here between the pleadings. We've already picked up the fact there's the disparity between the claim form and the particulars of claim. And for whatever reason, the one thing that is clear in this case is that Mr. MacDonald did not pursue the case in the particulars of claim. But he didn't pursue the case in the claim form either, because the claim form, as we had the exchange earlier between Lady Justice Simler and my learned friend, was dropped paragraph 1A of the claim form and only left in paragraph 1B. But the only point I'm making here is that if my learned friend is going to try to duck the fact and to, in effect, to say, well, the judge was on a frolic of his own, I don't accept that. In other words, the judge was being led by Mr. MacDonald to depart from his plea, to permit him to depart from the pleaded case. And to permit him to depart from the pleaded case, Mr. MacDonald was arguing for the 4th of April around the VAT document, and the judge came up with a different solution. The judge is not entitled to invent the case. In other words, even if you are going to allow a party to depart from the pleadings, you still have to at least structure it around what that submission is. And nobody in this, it seems, in court, Mr. MacDonald has tried, nobody's really trying to defend this judgment at all. Indeed, my learned friend helpfully was pitching in and suggesting it was wrong for different reasons, namely that there was some misunderstanding about the advice.
There's no respondent's notice, so we don't have to deal with that.
But what I don't, so Mr. MacDonald is firmly in the frame for the judge being misled, is that submission. The second point is
but we're not here to apply, we're really not here to allocate blame.
No, the point I'm making
may have gone
is,
wrong, and if so, we'll say so, but I don't think we'll be saying it's all somebody's fault.
I'm not suggesting, what I'm suggesting is that if the court is being led to think that the judge was on a complete frolic of his own, then we say he wasn't. He was trying to fill the gaps, the evidential gaps, as a result of the shift of the case. That's all I'll say. That's the important point, though, because you're moving now to deal with the second point.
To deal with what?
Can I just deal with the VAT argument, first of all? The difficulty that my learned friend had, and he was repeatedly asked by the bench here to answer simple questions. This is a contract. It was put by all of your Lord Justice and Lady Justice. This is a contractual case. It really shouldn't be that difficult in a case about a contract to answer the fundamental questions that your lordships and ladyships were repeatedly putting to Mr. MacDonald, which is when, how, where, and when was the relevant contract made, and when, how, where, and when was the relevant amendment made.
We'd all be out of business if it was that easy.
The point, it shouldn't be that difficult, but the important point for this submission is that my learned friend was repeatedly unable to answer the question. In other words, and the evidential gap pertained, irrespective of which date you opt for. There was no evidence to support and no case advanced in relation to the August 2012 situation. We can do them backwards. There was no evidence to support the hybrid that the judge has come up with. And more importantly, there was no evidence to support any suggestion that Gary Keane acceded to what I'm calling the VAT partnership.
I mean, just answer this for me, because I think this raises just slightly broader questions than maybe we're thinking about at the moment. If a judge is faced with a difficult factual position, and the pleadings are, and nobody will take this amiss because I don't think anybody's name was on the pleading, it was in court. Pleadings are a bit all over the place, and it does happen in litigation, even business and property court litigation. Is it not open to the judge, as Mr. MacDonald submitted, to do his best to piece together what he thinks on a balance of probability must have happened, and make findings along that line? Or is it right, as you have said, and we forcefully have put to Mr. MacDonald in argument for the sake of elucidating the question, is it right that the judge is only able to make findings on the basis of evidence, and if there is no evidence, he cannot draw inferences from the absence of evidence to decide what he thinks on a balance of probability most likely occurred? And if not, is that justice?
The answer is yes to both questions in one sense. In other words, the judge is plainly allowed to draw inferences from facts.
Yes.
What he can't do is invent facts or draw inferences from facts that are not there.
Or from disputed facts.
Well,
if the facts are accepted, then he can draw inferences so long as they're reasonable.
I
But
agree.
if the facts are disputed, is it open to him to draw an inference?
No, he has to make a finding first of all. In other words, that's the way I've always understood it, both as an advocate and as a judge. You make the reason you make the findings of fact first is because only by making the finding of primary fact can you then draw inferences. But what it's not open to do is to infer facts, which is really what he's done here. And I do want to just deal in passing with the suggestion, quite extraordinary submission that my learned friend made, to try to suggest that there was somehow a missing email trails relevant to the issue before your lordship. That wouldn't
I don't think we're very interested about speculating.
But
about
it's
missing
just
email
not true. The point
No.
is the email trail came to an end insofar as there was an email trail after the 10th of May, quite consistently with the defendant's case. It came to an end because, of course, he'd said no. He'd said no to the shares. So, but anyway, that is the point. The answer...
So just very specifically, Mr. MacDonald says, well, look, there were masses of emails before, between the 10th of May and the 18th of June, there's an absence of emails. I mean, is that factually correct?
There's an absence of emails about, well, other than that the court has seen, but there was disclosure statements that were made that were verified, there was no application for specific disclosure in relation to any missing email. The 25,000 documents that ended up in the trial bundles were extensive, but mostly directed to things that were completely irrelevant, which is why, between the adjourned trial and the new trial, we insisted, as indeed the judge did, on a proper core bundle. But the suggestion that there are somehow missing emails that are relevant to the issues before your lordship, as to the central question of when, why, where, and how, is just not true.
I mean, the judge, I think, somewhere refers to the fact that some emails will have been deleted. I mean, not nefariously, but simply with the passage of time, therefore they won't be there.
There was not a scrap of evidence, and let's face it, if Gary Keane's case was, I believe there are emails that are missing, and therefore the court is not getting the full picture of the story, he would have said so, but he didn't. So it's a red herring, and it's quite wrong in my submission for it to be raised again here, as if there's somehow some lurking doubt. I mean, that's, I assume, what my learned friend's trying to create, is a picture of some lurking doubt.
Does the burden of proof have any
I
role
was
to
going
play?
to come on, if I may, to deal with the burden of proof, because the other answer to the Master of the Rolls question is this, that sometimes judges have to decide the case on the burden of proof. In other words, and here, we've already established, this was a pretty unusual case in that Gary Keane purported, and I don't resolve from that, to not remember anything about it, despite the fact that he said he'd reviewed the documents. Now, in that there have to be some cases which fail because the claimant fails to prove his case. And that's what, in my submission, is the ultimate proper outcome for this appeal, is that your lordship should accept that in the light of the evidence that was undisputed about what happened on the 10th of May, whatever offer was outstanding at that stage had plainly been rejected.
So
Yeah.
if you, something I meant to ask Mr. McDonald, and I'll give him the chance to say something if he wants to. You say, if you win on that point, that the claimant failed to prove its case, whether it's pleadings or any other reason, failed to prove a case and the evidence wasn't there for the judge to reach the conclusion he did, as you say. You say we should just allow the appeal and dismiss the case.
Yeah, absolutely.
And because if Mr. McDonald wants to say something different, like, for example, there should be a retrial, then in that situation, then I'd like to hear him on that.
This is plainly, there's
No,
plainly...
Not now.
Well, I mean, if you want to, would you be short on that?
Yes, my lord.
Yes. Yes, well then now, yes.
Well, my lord, it entirely depends on your lordship's treatment of the judgment and the conclusions that your lordships. I'm assuming this is a judgment against me.
I think it would have to be, wouldn't it, if that were the conclusion?
Your lordships have. I'm envisaging a hypothetical judgment against me based on the submissions which your lordships have been hearing. But it would, I would expect it to include indications as to what your lordships thought the true facts were on some points. It would depend.
What do you say about that?
Well, again, subject to what your lordship said in the judgment, I have been envisaging that I might be in a position either to ask your lordships to come to conclusions disposing of the differences between the parties in a different way from the way the judge disposed of them, or alternatively, giving me the opportunity to ask for a new trial. So, I mean, I've been contemplating and...
But it sort of slightly depends what we did say.
Exactly.
So that's why you were silent on the point. And what you're saying is, if there is any, if the reasoning leaves any prospect of your succeeding at trial, at a new trial, you would ask for one.
Yeah, absolutely.
Yeah, well, I get that. Okay, thank you.
Lord, Lord and Ladyships, while I sat down, I was reminded by my instructing solicitor of just what I'd said at the beginning of the closing submissions on the pleading point. I'm not going to read it out, but could I just draw your attention to it's day 5 of the transcript, which you're going to be given with in due course. It's page 99. There's a passage starting at line 7 through to line 3 on.
Just give us a hint about what you said.
Oh, I will read. I said the starting point, so far as the partnership claim is concerned, is that we have to go back to the pleadings. In my respectful submission, it's quite plain and obvious that the case that is now being advanced by my learned friend, on behalf of Mr. Keane, is simply not the case that was pleaded, and not the case that we came to meet. Indeed, not what we will show in a moment, the case we have met. In those circumstances, that gives rise to a plain and obvious procedural unfairness to my clients. The obvious solution to that is that my learned friend must be held to the pleaded case. There has been no application to amend. Your Lordship has heard me on various occasions rise, and I know at the risk of perhaps annoying your Lordship, and I apologise for some of the interventions, or perhaps for excessive intervention in the early part, but the reason I rose is because I foresaw that this is where we were going, and that it was appropriate that I made sure that Mr. MacDonald therefore put the case properly to the witnesses.
And the answer to that was not, I apply for leave to amend.
Yes. Lord, I was simply going to make...
Sorry, I think this is a red herring, given that, as we've indicated before, we don't really see the case turning on the pleading point. But when you say you were prejudiced by the change of case, it's not obvious to me that you really were.
Well, not if I win here. I was if in the circumstances that happened, because let's suppose two things could have happened. The judge might have just accepted Mr. MacDonald's case, i.e. that there was a partnership arising around April from the VAT document. In which case, I would have been less prejudiced in the sense of being taken by surprise by that, because by the closing I clearly knew that. But of course, I hadn't cross-examined anybody around there being a partnership in April 2012, so that's where the prejudice.
Can I just break that? I mean, the question is, were you prejudiced, or a question is, were you prejudiced by the fact that this case had not been pleaded?
Well, yes.
You said a moment ago, well, you were prejudiced in the sense that you didn't know you needed to cross-examine Mr. Keane on these points. Well, in the event, of course, the judge didn't really attach any weight to Mr. Keane's evidence, so that's not a matter that counts.
The answer is, there was the potential for me to be prejudiced as a result of it, because I had not cross-examined to an April partnership. However, as it happens in this rather unusual case, I was able to go on to make the submission, and I think it's presaged in that part, that even whatever date you were going to choose for a partnership, there was no evidential support for it. So I'm not saying, just if I perhaps answer it slightly the other way around, I'm not saying, for example, that we would have adduced different evidence in relation to it. But certainly if I'd known that that was the way it was going to be put, I would have cross-examined about it. But remember, I was in the slightly unusual position that I identified yesterday, where Gary Keane had said absolutely nothing about it. And so my issue was, why would I want to let him improve his case? He had given no evidence at all, other than a bland statement, as to when or how he'd become acceded to the partnership. So even if so I was not prejudiced in the sense that I was still able to argue that as far as the April partnership was concerned, there was simply no evidence of any accession. And that remains the position here today. That's why I say that we must win on that point. I don't think I was going to... It's just one very small point, which is that it seems to be being suggested and maintained by Mr. MacDonald that the scheme couldn't work unless he was to become Gary Keane was to become a shareholder. I think your Lordship just knew it dealt with that, but I mean the answer is it plainly could work. The scheme could work perfectly well. The only other point I would make is that if you look carefully at the VAT documents, in other words, the position on the VAT was that if you have a supplemental bundle of documents. It's really page 271 and page 272. It's 272 I want to take you to really, but it was the response that was submitted on behalf of the parties to HMRC, and you can see that this is in June 2012.
It's quite hard to see the page numbers, but which tab is it?
Sorry, it's tab 27.
Thank you.
It's really the page 272 that I'm taking you to.
It's the
So-
response. It's
Yes.
the submission
Yeah.
to the Inland Revenue that Kingston Smith put in.
Yeah, and it's the response, and it says that it was controlled by 4 individuals.
And they
So-
needed 51%, and they had 51% on any view.
And the point there is that Gary Keane's case, therefore, would be very odd indeed if there had been an earlier agreement whereby he was to become a partner, if that response would have been put in, because it was post date the 10th of May, obviously because it's June, and ergo is entirely consistent with the defendant's case. Unless your lords and ladyship have any questions as well.
Well, thank you both very much indeed, and thank you to your solicitors. It's been an interesting couple of days or day and a half. We'll take time to consider our judgments. We'll hand them down in the usual way. Be aware of, not that it perhaps would be most significant here, but be aware of the embargo and the terms of the embargo on the judgments. You may only look at them and circulate them for the purposes of agreeing an order and agreeing the disposition and costs. If we need any other submissions and you can't agree an order or the disposition of the appeal, then those submissions will be in writing, and you can agree a timetable or ask us for a timetable if you can't agree. But that, I think, concludes the hearing. Thank you.